Throughout his judicial career, Judge Eisele has always been a defender of constitutional rights for all. His most recent civil rights opinion, issued in 2010, involved racial profiling of Hispanics. In 2007, 8 plaintiffs filed a class action complaint in federal court. They alleged that an Alexander police officer had violated their constitutional rights by targeting them for traffic stops based on their race. The offense used to justify the stops, windshield obstruction, was based on objects such as rosary beads or air fresheners hanging from their rearview mirror or stickers on their rear windshield. Another plaintiff complained that the same officer had summoned him from inside his home and then cited him for drinking in public and disorderly conduct after he failed to produce a driver's license quickly enough to suit the officer.
This officer would be out on patrol. He would identify someone that he could tell was Hispanic, either by the way they looked or maybe by something on their car. And after he identified them as being Hispanic, he would find or make up some reason to stop them. He would stop them, and then he would just issue them every citation he could, tow their vehicle, and it was very profitable. So it came out very well for the city of Alexander. Well, right up to Judge Eisele got involved.
Shortly before trial, both parties withdrew their jury demand.
Once we filed the lawsuit that included the jury demand, and I got Judge Eisele, I knew I had a fair judge, and I knew I had someone who was going to look at the merits of the case rather than my client's skin color and immigration status and stuff. So I basically thought that I was afraid that a racist juror would derail my case for no other reason than that my clients were Hispanic. And so I decided that I would rather have this decided by a fair judge than an unknown jury.
Although the case began as a class action, when the case came to trial, only a handful of plaintiffs remained.
We started out with upwards of 40 potential plaintiffs, and I can't remember the first morning of trial. I may have had 2 show up, something like that. It was disconcerting, but they did show up, a couple of them, and after the first day, they saw, wow, this judge is, he's listening to what we have to say. He's sitting up here, and we get the feeling that we may get some justice here. So they tell the other people, and then so we had more come, and I don't know, we wound up with maybe 7, something like that.
At trial, the defendant officer testified that he learned at officer training that it was against the law to hang anything from a rearview mirror. And so he started enforcing that violation of the law. Although census figures put the number of Hispanics in the area at between 2 to 6% of the population, 68% of all the windshield obstruction tickets the officer wrote were to Hispanics. Plaintiffs were able to present direct evidence that the officer targeted them because of their race.
There were a couple of witnesses kind of within the department. One was a former officer, and one was a guy who was just a friend of this officer and would come and ride along. And this towing these vehicles began to be such a big deal that they made a game out of it. They called it Tow My Ride. And I guess on MTV there was a show called Pimp My Ride or something, and they were sort of making a parody. And this was a game. They're towing these people's vehicles, taking their property, charging them lots of money, writing them every citation they can, and it was a game to these people. They thought it was fun.
The plaintiff's case was also aided by testimony from a former city judge and prosecutors.
Fortunately for me, the mayor and the police chief just couldn't assert enough influence over the judges and prosecutors down there to make this work for them. I had a former judge, and it seemed like a couple of former prosecutors come and testify at the federal trial. And the story was the same. The former judge testified that it seemed like there were a lot of Hispanics in court and that he was under pressure to always put maximum fines on these people. the same from the prosecutors, that they were under a lot of pressure to prosecute every case, not to plea bargain things down, come up with max fines. And one of the former prosecutors actually testified that well, first the prosecutor told me that she couldn't make cases. The officers did not have probable cause to stop these people, and that they didn't violate the law. And so she would have to dismiss these cases. And the mayor came to her and said, if you keep dismissing these cases, the money we lose is coming out of your paycheck.
One of the plaintiffs, Florencio Villanueva, was in a different situation. The officer had received a call about a speeding truck in the area. After spotting a truck sitting in Mr. Villanueva's yard, the officer had someone ask Mr. Villanueva to come outside. When he did, he had a beer in his hand. The officer arrested him and cited him for public intoxication and disorderly conduct.
He was handcuffed, set in a police car for some amount of time. Seems like maybe it's 15 or 20 minutes, something like that. And Judge Eisele decided that that was a violation of his Fourth Amendment rights, and Mr. Villanueva got, I believe he got the highest award of damages of any of the plaintiffs in this case.
In addition to finding the officer liable, Judge Eisele imposed personal liability on the police chief and municipal liability on the city. Judge Eisele imposed punitive damages on the police officer, but he took under advisement the amount of those damages. As defense attorney John Wilkerson explains,
well, it gave us a chance to take a step back and try to settle the case around the judgment itself and to prevent punitive damages from being assessed against the individuals, which is always the biggest fear. So by Judge Eisele allowing us to do that, it let us have that chance and then go to the city and say, listen, we do have an order against us right now. It's not a judgment yet. We have some potential additional damages against the individuals. Let's see what we can do to appease the plaintiffs, save us some, whatever we can save ourselves at this point. And by the judge letting us do that, I thought that was you know, like I said, it may not have been legal jurisprudence, but it was reasonable prudence on his part to let us have that chance. And I appreciated it. And I think that it helped the city. And I think it helped the plaintiffs too, because we were able to give them a little bit more than even the order said that they were going to get, like a change in the way we did things. I was actually at my grandma's house talking to my grandmother about family business, and I got the order on my phone. And I sat there and reading it, trying to pretend to listen to my grandmother and read it at the same time. And I was disappointed by the order. Obviously, I didn't like losing. And I believed my clients at the time, and I still like to say that I believe them now. But after reading the opinion and reading the way the judge viewed all the facts, I see why he viewed them that way. And the application of the facts to the law was spot on. I have no legal argument that I could make against this. It's 89 pages. That speaks for itself. And then after reading all 89 pages, it's as good as it's going to get.
After the ruling, the officer and the police chief both resigned. Their salaries, along with funds kicked in by the Municipal League, were used to settle the lawsuit. Even though the compensatory damage awards were relatively small, they had a large impact on the plaintiffs.
It truly, and a lot of people say this, a lot of people say it's not about the money, but it truly was not about the money. By 3 years going by, and all the time these people missed work to go to depositions and worried about this and sweated it, it truly wasn't about the money. They were ecstatic to have won. What it was about for them was they simply couldn't believe, I don't know how long it took to sink in, that they had gone to a federal courthouse here in Little Rock and gotten a federal judge to believe them over a police officer and to write this 89-page opinion that the police officer was wrong and that they were done wrong. That was overwhelming to them.
He's a picture book judge. He is dedicated to justice. He's very smart, and he's overcome his Harvard education, and he's practical. You know, Harvard's where they say, we know it works in practice, but will it work in theory? Well, Judge Eisele is a very practical person, and when you walked into his courtroom, you felt like you were walking into the Temple of Justice. You knew you were going to get fair treatment. Your client was going to get fair treatment, and he's a German, and he's pretty stern, but he's reasonable and he's fair. Judge Henry Woods told me back when we were practicing law together, said that if you treat Judge Eisele halfway right, he'll treat you 100% right. And he was always fair, and he was very tolerant of vigorous advocacy. He didn't get ill at lawyers for getting a little overamped at times. He was patient with them, and he runs a taut ship, but he was a picture book judge, and even though he's German and hard-headed, if you could show him he was wrong, he would reverse himself. And unfortunately, that's too rare amongst judges.